Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners attuned to these issues who want to hear what the experts in these fields are thinking about. Each episode is produced by one of the specialty committees within the section. This episode is presented and co-hosted by the Civil Practice and Procedure Committee of the Antitrust Law section. The subject of today's episode is how the use of economic experts in antitrust litigation has gone astray. I'm no good at math. That's why I became a lawyer. We've all heard someone say that. Yet for all the jurists who bizarrely celebrate their mathematical illiteracy as a reason they became lawyers, antitrust has a special appeal for many of us precisely because it combines legal interpretation and elegant mathematical precision. But numbers can create a false sense of certainty and mask a host of subjective assumptions built into these economic models. Assumptions that can be tweaked this way and that to arrive at different or less conclusive findings. Over the last decade, a backlash has been building, notably from the progressive left, to a perceived over-reliance by the courts on testimony from economic experts. One of the root causes of the greater prominence of economic experts in litigated cases has been the shift by the courts over the past half-century to more rule-of-reason-based analyses under the consumer welfare standard. Rebecca Allensworth has described the increasing centrality of rule of reason in antitrust cases as a delegation of authority from judges and juries to economic experts who, in some instances, determine the application of antitrust rules. The analyses themselves have become even more difficult for non-specialists to follow. Former Deputy Assistant Attorney General David Gelfand decried the inscrutable mathiness of antitrust economic publications, with comprehensible abstracts and conclusions bookending pages of gibberish written only for an audience of their peers. The business of professional antitrust economics has also become a source of backlash. You don't hire an economic consulting firm, say the critics, to come up with the true answer to the competitive effects of a merger, any more than you hire a painter to paint the true color of your home. You hire a painter to paint the room the color you want it to be. It's like the old fast food slogan, your way, right away. Economist Orly Ashenfelter critiqued the approach used by some of these firms to ProPublica, saying, "The answer is known in advance, either because you created what the client wanted or the client selected you as the most favorable from whatever group was considered." Litigated antitrust cases are now, aptly and often resignedly, described as boiling down to a battle of the experts. And the expectation that both sides will come loaded for bear with regression analyses means that the cost of litigating cases has gone up, with retention of external experts placing a real constraint on how many cases enforcement agencies can bring. Senator Amy Klobuchar introduced legislation that would de-emphasize economic analyses and introduce more bright-line rules and presumptions in an effort to rein in the escalating cost of litigating an antitrust case. With more cases being decided by rule of reason and market pressure for made-to-order results and economic analyses that are even more complex and harder to fathom, some longtime practitioners bemoan that experts end up canceling each other out as judges turn to non-economic evidence to decide their cases. This raises a number of important questions for us to consider here today. Have judges gone too far and become too reliant on economic experts in antitrust cases? Short of reverting to more per se rules, is this trend irreversible? And what should a judge do when confronted with too dueling, the scientifically sound, Daubert-blessed economic conclusions? For this episode, I'll welcome back as my co-host, Travis Wheeler, a partner at the Nexon Pruitt Law Firm and an adjunct professor at the University of South Carolina School of Law. And our guest today has firsthand insights from decades as arguably the most renowned antitrust plaintiffs lawyer in the country. Welcome, Travis.
Thank you. And our guest today, this is not to overstate things, is Michael Hausfeld. He is a true titan of the bar. He's brought some of the most groundbreaking and important cases of our time, including helping Holocaust victims recover stolen property and assets from Swiss banks, being among the first to assert sexual harassment claims under Title VII, and representing victims of South African apartheid. It is a remarkable record, and we haven't even touched on antitrust. He has done a few things in that area, too. He has litigated decades of cases on behalf of individuals and classes under Section 1 and Section 2 of the Sherman Act. He recently represented college basketball and football players against the NCAA to establish their rights and name, image, and likeness compensation. He has been lead counsel on antitrust cases against genetically engineered food manufacturers, managed healthcare companies, bulk vitamin manufacturers, technology companies, and banking institutions. So thank you, Michael. We are going to be talking today about the role of economics in an antitrust case and whether antitrust litigation has become too reliant on economic analyses. And this podcast started off as an idea for a discussion on Daubert motions in antitrust cases. We are going to talk about experts in antitrust cases, but as this came together and took shape and evolved into something more of an idea for a higher level discussion on the role of economic experts in antitrust cases and courts' increasing reliance on economists in such cases. And kind of before we get to the experts, Michael, I thought I'd just ask how the role of economics in general in antitrust litigation has changed over the course of your career.
Thank you, Travis. There was a time, in the 60s and 70s when there was more antitrust enforcement going on in the United States, where economics played a relatively small but not insignificant part, in antitrust litigation, where at the initial stages of the litigation, when a defendant usually filed a motion to dismiss, plaintiff's expert merely had to state that, yes, it was reasonable to draw conclusions based on generally accepted economic principles regarding the conduct in question. That has changed dramatically to where even at the motion to dismiss stage, you are approaching pretrial determinations by the court as to whether or not the allegations are sufficiently plausible to allow the case to proceed.
Mm-hmm. And has this changed, or is that coupled with the rise of the Chicago School?
I'm not sure whether that was coupled with the rise of the Chicago School, but rather the complexity of business behavior that changed over time, over the view of judges that they could not determine the carrying of the burden of proof based upon evidence that did not give them an insight into the economics behind the conduct that was being contested. Economics involves two major themes: anti-competitive conduct and then anti-competitive harm. So what conduct crosses a line which society or the administration or the law has determined will hold the perpetrator accountable? And then even if you cross that line, has that conduct caused harm, and how do you identify and quantify that harm? In the introduction, there was reference to mathematical precision. The mathematical precision only relates to the measurement or the calculation of damage, but the damage, follows the establishment of the existence of the harm in the first place. So mathematical precision is not the end-all and be-all of the economic testimony. It is what is the context of the behavior which is being focused on, in terms of whether or not it did cross an anti-competitive line as determined by our antitrust laws, and then whether the crossing of that line caused harm and to whom.
And in talking about the ever increasing reliance on economics and experts in particular, I wanted to raise one case that predates Daubert by a few years, the Matsushita Supreme Court case. I think it was 1986. Is that case indicative of courts sort of increasing reliance on economic theory and a kind of a step towards where we are today?
I don't think so. I think that case, again, when you look at the essence of the majority opinion, um, dealt with the dismissal of the claim because it believed it was a senseless conspiracy. It was a conspiracy that the majority of the justices felt made no economic sense. There was not a great deal of economic either justification or explanation of the behavior. I think as businesses got more sophisticated, and I think if you look at the evolution of what courts were looking at in terms of industrial misconduct to now digital market misconduct, you see the rise in complexity of the misconduct that is being questioned, and the need for economic analysis as to exactly what occurred in the market to determine what is the market and whether or not that behavior, whether it be horizontal or vertical, caused harm that the antitrust laws were designed or intended to protect. So there was a need, really to at least accept economic analysis. But then you have the question, I think, again, as it was raised in the introduction, of the battle of experts. Clearly need to understand that you have credentialed experts on both sides of the defense and the prosecution or the plaintiffs. Dalbert was intended to eliminate junk science. You're not getting junk science from credentialed experts. At one point, when we were introducing private enforcement outside the United States, um, a justice on one of the European courts said, "Well, why do we need economists? Why don't I just go to the merchandise manager, to find out how much cheaper he felt he could have bought this product if there really was collusion and cooperation to inflate the price of the product that he was buying." I, I think clearly that view of the need to be educated by the economics of the operation of a market has long become obsolete. But now the issue is, have we gotten too much reliance, on economics, as well as, to me, one of the best insights into economics and their relation to resolving antitrust issues was the um, oral hearing in the Comcast decision, where the courts related economics to the purpose of Rule 702. Did the testimony really assist the trier of the fact in understanding the facts at issue? Is there a fit between the economics and either the claims or the defenses? And that's where I think we have lost our way somewhat.
Stepping back and looking at the purpose of experts as assisting the triers of fact and or educating a jury, then it is possible to have two experts with different opinions, um, both of which are capable of educating and helping a jury.
There are two examples that come to mind. One is the famous Harry, Trumanism, and that is that he wanted an economist that only had one arm, so that he didn't have to hear, but on the other hand. Um, and the fact that several years ago, the Nobel Prize in Economics was shared by two economists, both of whom, looking at the exactly same set of facts, came up with totally opposite views as to how to resolve or reach an outcome. You're absolutely correct. In terms of economics is not a precise science like quantum physics, for example. It's based on assumptions and hypotheticals, And if you change the assumptions and the hypotheticals, you may come up with different outcomes by different, by different opinions through different economists. Does that mean that either one of them is using junk science? Or does it mean that one of those opinions may not really assist the trier, in reaching a decision as to what actually happened by a preponderance of the evidence?
And you've touched on this already, but just to reiterate the point that typically in big ticket antitrust cases, you're not seeing a lot of junk science pulled into the fray. They're pretty credentialed and knowledgeable economists. But in your practice or today, how frequently do you see experts subjected to Daubert motions?
More so on the side by defense counsel. They always want to Daubert, the plaintiffs, experts, and that is an interesting point of history. Before the federal rules limited depositions of experts to 7 hours, you would have to sit for depositions of experts. I think the longest that I ever experienced was 27 days. And there's not that much really you're going to get out of an expert after that long a period of time. And then there was one time where I was deposing Alan Greenspan, in an antitrust case, and he was represented by 5 major New York firms that had a crew of lawyers behind, the 5 firms, and we were going back and forth. And I candidly, I was not just young but naive at the time. I wasn't quite sure about the rules, of deposition, and so I was just kind of asking questions, in a conversational tone, to which literally there was an objection raised to every question that I asked. And at one point, Dr. Greenspan pounded the table and looked at his counsel and said, "Would you please stop that? Can't you see I'm trying to have a conversation with this young man?" And that to me was the essence. You're trying to see where the opinion fit what occurred and how he could explain his economic theory as being a reflection of the reality of what was being focused on. And I think we have lost that. We have gotten cast, into the abyss, of just fighting over data points and theoretical assumptions and conclusions, which are nothing more than an effort to create complexity and confusion, which is not to say that the plaintiffs don't try to create simplicity, but between the two, only one can hopefully explain, what occurred.
And I'm going to sneak in one practical question related to this, but when you take a deposition of an opposing party's expert, what is your goal in doing that? What are you trying to achieve?
There are 2 goals, a negative and a positive. My goal is not to try to out-expert the expert. That's just not going to happen. I'm not an economist. They're always going to be able to pull up, theories that I am unaware of and apply them in ways, that I again confound the question. What I try to do is what I did, with Dr. Greenspan: get a conversation going and try to have the witness focus on how what he is saying really explains what it is that I think, went wrong.
And is it overstating things to say that the battle of experts has almost become a zero-sum game? in litigation?
It's almost become the end game in some litigations because now, for example, at class certification, which is just, as it said, a procedural device, really, it is no longer just an argument of counsel. It is no longer a presentation of certain facts and excerpts of deposition testimony, videoed, at a hearing. It's a full-blown hearing, sometimes lasting a week or more. It's a mini trial. There's no question about it. And if the court has to decide who won the battle of experts on the basis of a predominance, of evidence, who was more right than not, isn't that the function of the jury?
And this may have answered the question I'm about to ask, but just to reframe it a little bit differently, if my expert has a model that reflects no damages, and your expert has a model that shows that there are damages, does that mean one of them is unreliable?
Does it mean not that is the ultimate opinion unreliable, but is it sufficient to preclude the continued procedure of the case beyond that battle? I am one on the plaintiff side to admit I don't think that there is a precise number that any economist can say with any degree of certainty, this should have been the exact price. There's always a range. And if there's always a range, then if you say, on one hand, and this gets, to Truman, that there was no damage. In fact, usually sometimes in the early days, defense economists would say, not only was there no damage, but you owe us money. You benefited as a result of our conspiracy. And you have the plaintiffs, experts say, yes, there was the damage, and this is how I calculate it. There always should be a range. And that range should belong to the jury to determine.
Yeah. If we are sort of too dependent on experts, where does that leave us? And
it depends on what you mean by too dependent. Courts now view themselves as having a gatekeeper function at a number of different points in the litigation. The first, clearly, as they should be on a motion to dismiss. The second, if it's a class or a collective action, at the time of certification, to exclude junk science. And then the issue is, even if they don't exclude it at certification, do they have the ability as well to have that revisited at the time of trial, if it's raised, by the defense to exclude certain testimony as going beyond, reliability? And then the jury. The jury hears both sides of the experts, but as well, hopefully, as the facts, and puts it all in context, and is supposed to determine, on the weighing of all of the evidence, not just the economics, as to whether or not there was conduct engaged in, by the defendant or defendants, which crossed the line. I don't know how precisely, to compartmentalize each of the gatekeeper functions, but if there is a valid disagreement of opinion among equally credentialed economists, I believe that the ultimate decision should belong to the jury.
And just to kind of circle back to the Matsushita case, because I think if you look at the majority opinion there, that talk of the economically senseless conspiracy, the economically senseless justifications, it's hard to you'd be surprised to learn that it was a 5-4 opinion, with the dissent saying, well, if the plaintiff's experts had been allowed to testify, they could have explained why it wasn't economically senseless at all. And has the exclusion of the party's experts become more of a silver bullet?
I think there are cases in which more plaintiffs' experts have been disqualified from testifying about what evidence would be admissible than the other way around. Let me give you two examples of the opposite, of the lessening of deference to the Chicago economics theory. Book litigation dealing with predatory pricing. There is now clearly a body of economics who believe that Brooke, was incorrectly decided on economic grounds because the rule laid down in Brooke was just impossible, for any plaintiff to establish that there was an opportunity of the predatory pricer to recover or recoup within a short period of time. That's almost impossible to prove. And so they would like to have the Brooke decision re-examined in light of present-day economic thought. Likewise, a more recent or contemporaneous example is the American Express case, which was touted, by many on the economic right as setting forth a new economic analysis dealing with two-sided markets, and the economic left saying almost everything we engage in is a two-sided market, and so the case has to be confined to the literal facts in which it was presented, and that was a simultaneous transaction. Again, a disagreement not just as to the economics, but of the economic thought behind the application of a possibly overused set of economics thought.
And Brooke Group is an interesting case to bring up, and it seems almost that following that case that that economic theory or an economic opinion trying to explain predatory pricing conspiracies is almost as a matter of law junk science following Brooke Group.
Yes.
Yeah. Okay. Any other thoughts about the abyss and how we might pull ourselves out of it?
I think there is now a counter school of economics to the Chicago school, which is not to say that it is on the spectrum at the extreme other end, but is trying to find the middle. And that is, to say economic thought has evolved, economic thought has progressed where they can, for example, get more accurate predictions or forecasts as to what a competitive price would have been in the absence of collusion, but also in explaining, for example, whether or not a cartel has to be perfectly effective in order to cross a line of engaging in unreasonable restraint, or at least sufficiently, effective in doing that, so that all members don't have to abide by the cartel rules on every single transaction. One of my pet concerns has always been a defense argument, for example, opposing class certification, in terms of the class having to demonstrate that every member of the class was impacted and damaged. I call that the needle in the haystack argument, and that is their argument really is if you find a needle in the haystack, just one needle, then there's no haystack. That makes no sense to me.
So this has been fascinating. I especially enjoyed the anecdote about deposing Alan Greenspan. It reminded me of a deposition I attended years ago where the first chair kept up this Gregorian chant-like undertone of objection to form, objection to form, objection to form. So I really enjoyed that one. And I also like this the historical arc, Michael, that you provided from the use of economics at an earlier time through Matsushita, Brook Group, Amex. But even offering some hope here to Travis's Nietzschean question about what happens when you look into the abyss long enough, and the answer was maybe like a post-Chicago kind of approach to economics. We like to end these shows by asking our panelists for some takeaways for practitioners, and so maybe I'll start with Travis. Travis, what are the key takeaways for practitioners from this discussion as you see it?
I think from a practical standpoint, two that come to mind. First, experts matter, and fair or not, especially from a plaintiff standpoint, an excluded expert in an antitrust case can sometimes be a litigation death knell. Second, if we start from the premise that the purpose of the expert testimony is to assist the jury, the trier of fact, then the mere fact that the parties' experts reach different conclusions or disagree doesn't necessarily mean that either one is unreliable or should be excluded. And I will leave the bigger takeaways to Michael.
I totally concur in Travis's observation that because two credentialed economists may disagree, that you throw one of them out. If you feel you should be able to do it at a stage short of the jury. I think that digital markets right now emphasize the utility of economics in particular because they are far more complicated than traditional cartel analysis, whether or not there was a conspiracy, which is whether or not you sat down with your competitors to agree on, what price, for example, a product or service should be sold, and what happens in a digital market that may cross an anti-competitive line and cause anti-competitive harm. You've got a lot of different economic thought, which is still even evolving as to how to explain the operation of those markets. And I believe it's clearly necessary for that to develop and for the court and the jury to hear how that plays out in terms of that economic thought. But also, I feel that there's got to be more economic thought at the policy level in terms of the debate between Borkian versus Brandesian, policy, whether you're looking at, consumer welfare or competitive welfare, or there are interests other than just the consumer that are involved in antitrust policy, whether it be labor, whether it be shareholders, whether it be privacy, whether it be democracy. These are all issues that are now coming to the forefront, and economics is a good background and foundation upon which they need to be built. So I think there's a tremendous future for the rethinking, of antitrust thought. I'm not sure where it comes out. I'm not trying to say where it does, but clearly the difference between European approach and an American lag, I think is indicative of a gap that we need to adjust to see exactly how we arrive at what new conduct we feel antitrust law should reach, what interests should be protected, and how those protections are to be applied and interpreted.
It is the pivotal debate in our field right now, and I think also what makes our field such a fascinating one to be in at the moment. And certainly going to be the subject of many episodes and panels to come. So thank you, Travis. It was great to have you as a co-host on our show again. Thank you as well to the peerless Michael Hausfeld for joining us. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.